Registration of firm. Important questions from this topic are: first, what is the procedure for registration? Second, what are the consequences of non-registration? Third, is the registration of a partnership firm compulsory? Fourth, can a partner of an unregistered firm bring a suit against a third party to release the property of the dissolved firm? Chapter 7 of the Indian Partnership Act, 1932 deals with the registration of firms. Under this Act, registration of a partnership firm is not compulsory. In other words, a firm can legally exist even without being registered, and there is no penalty imposed for non-registration. However, the consequences of not registering a firm are quite serious. An unregistered firm faces several legal disabilities, especially when it comes to enforcing its rights in a court of law. Due to these significant disadvantages, most partnership firms prefer to get themselves registered. Registration provides legal recognition and helps safeguard the interests of partners. Section 56 of the Indian Partnership Act, 1932 deals with the power of the state government to grant exemptions. It provides that the state government may, through a notification published in the Official Gazette, direct that the provisions relating to registration of firms shall not apply to the whole state or to any specified part of it. Moving to Section 57, it deals with the appointment of registrars. The state government is empowered to appoint registrars of firms and to define the territorial limits within which they will exercise their powers and perform their duties. Further, every registrar appointed under this Act is considered a public servant within the meaning of Section 21 of the Indian Penal Code, 1860. These provisions ensure administrative flexibility and proper regulation of firm registration across different regions. According to Section 58 of the Indian Partnership Act, 1932, the registration of a firm can be done at any time. The partners are required to submit a statement in the prescribed form to the registrar of firms of the area where the business is situated or proposed to be situated. This can be done either by post or by delivering it personally, along with the prescribed fee. The statement must contain essential details such as the name of the firm, the principal place of business, other places where the firm carries on business, the date on which each partner joined the firm, the full names and permanent addresses of all partners, and the duration of the firm. This statement must be signed by all partners or by their duly authorized agents, and each signatory must verify it in the prescribed manner. It is important to note that the firm name must not include words like crown, king, emperor, or similar terms that may suggest any association with the government. As per Section 59, once the registrar is satisfied that all the requirements of Section 58 have been properly complied with, the registrar records an entry in the Register of Firms and files the statement. At this point, the firm is considered to be duly registered. Alteration in firm name or principal place of business. Section 60 of the Indian Partnership Act, 1932 deals with the recording of alterations in the firm's name or its principal place of business. When a registered firm makes any change in its name or shifts its principal place of business, it must inform the registrar of firms. This is done by sending a statement specifying the alteration along with the prescribed fee. The statement must be signed and verified in the same manner as required under Section 58, that is, by all the partners or their duly authorized agents. Once the registrar is satisfied that all the requirements have been properly complied with, he will update the entry of the firm in the Register of Firms accordingly. The updated statement is then filed along with the original registration documents maintained under Section 59. This ensures that all changes in the firm's identity or location are officially recorded and legally recognized. Section 61 of the Indian Partnership Act, 1932 deals with the noting of opening and closing of branches. Whenever a registered firm starts business at a new place or discontinues business at an existing place other than its principal place of business, any partner or authorized agent may inform the registrar of firms. Upon receiving such intimation, the registrar records the change in the register of firms and files the intimation along with the original registration statement under Section 59. Moving to Section 62, it deals with changes in the names and addresses of partners. If any partner changes his name or permanent address, an intimation can be sent to the registrar by any partner or agent of the firm. The registrar then records this change in the same manner as provided under Section 61. These provisions ensure that all updates related to branches and partner details are properly recorded and kept up to date in official records. Section 63. Recording of changes and dissolution of a firm. Section 63 of the Indian Partnership Act, 1932 deals with recording changes in the constitution of a firm and its dissolution. When any change occurs in a registered firm, such as admission, retirement, or exit of a partner, any incoming, continuing, or outgoing partner may give notice to the registrar. Similarly, in case of dissolution of the firm, any person who was a partner immediately before dissolution or their authorized agent may inform the registrar. Such notice must specify the date of the change or dissolution. Upon receiving it, the registrar records the information in the register of firms and files it along with the original registration statement under Section 59. Further, subsection 2 deals with a minor admitted to the benefits of partnership. When such a minor attains majority, he has the option to either become a partner or not. He, or his authorized agent, must give notice to the registrar regarding his decision. The registrar then records this notice in the same manner as other changes in the firm. This provision ensures that all structural changes and dissolution of a firm are properly documented and legally recognized. Section 64. Rectification of mistakes. Section 64 of the Indian Partnership Act, 1932 deals with the rectification of mistakes in the register of firms. Under subsection 1, the registrar has the power at all times to correct any mistake in the register of firms. This is done to ensure that the entries in the register are consistent with the documents filed under this chapter. Further, under subsection 2, if all the parties who have signed a document relating to the firm jointly apply, the registrar may rectify any mistake in such document or in the corresponding entry recorded in the register of firms. This provision ensures accuracy and reliability of official records, thereby maintaining transparency and legal certainty in the registration of firms. Section 65. Amendment of Register by Order of Court. Section 65 of the Indian Partnership Act, 1932 deals with amendment of the Register of Firms by order of a court. When a court decides any matter relating to a registered firm, it may direct the registrar of firms to make necessary amendments in the register of firms. Such amendments are made to reflect the outcome of the court's decision. Upon receiving the court's direction, the registrar is bound to update the entry relating to the firm accordingly. This provision ensures that judicial decisions are properly recorded in official registers, thereby maintaining accuracy and legal authenticity of the firm's records. Section 66. Inspection of register and filed documents. Section 66 of the Indian Partnership Act, 1932 deals with the inspection of the register of firms and related documents. Under subsection 1, the register of firms is open for inspection by any person, provided the prescribed fee is paid. This means that the records maintained by the registrar are accessible to the public. Further, subsection 2 provides that all statements, notices, and intimations filed under this chapter can also be inspected. However, such inspection is subject to prescribed conditions and payment of the required fee. Section 67. Grant of copies. Section 67 of the Indian Partnership Act, 1932 deals with the grant of copies from the Register of Firms. It provides that any person can apply to the registrar to obtain a copy of any entry or a part of an entry recorded in the Register of Firms. Upon such application, and on payment of the prescribed fee, the registrar shall furnish a certified copy under his hand. Such certified copies serve as official proof of the contents of the register and may be used for legal and evidentiary purposes. This provision ensures accessibility of official records and facilitates verification of firm-related information. Section 68, Rules of Evidence. Section 68 of the Indian Partnership Act, 1932 deals with rules of evidence relating to entries in the Register of Firms. Under subsection 1, any statement, notice, or intimation recorded in the Register of Firms becomes conclusive proof of the facts stated in it, as against the person who signed it or on whose behalf it was signed. In other words, such a person cannot later deny the correctness of those facts. Further, under subsection 2, a certified copy of an entry in the Register of Firms can be produced as evidence. It serves as proof of the registration of the firm as well as the contents of any statement, notice, or intimation recorded therein. This provision strengthens the evidentiary value of official records and ensures reliability in legal proceedings. Section 69, Consequences of not registering a firm. Section 69 of the Indian Partnership Act, 1932 lays down the consequences of non-registration of a firm. Although registration is not compulsory, non-registration results in serious legal disabilities. First, suits between partners and the firm. Under Section 69, 1, an unregistered firm cannot file a suit against the firm or between partners to enforce contractual rights unless the firm is registered and the partner is shown in the Register of Firms. In the landmark case of Lucaran Sethia vs. Ivan E. John, 1977, the Supreme Court held that a partner of an unregistered firm cannot enforce contractual rights through a suit. The suit was declared not maintainable. Second, suits between the firm and third parties. An unregistered firm cannot file a suit against any third party to enforce contractual rights. In Ram Adhar vs. Rama Kirat Tiwari, 1981, the court held that since the firm was unregistered, its suit for recovery of price was not maintainable. Third, bar on set-off and other proceedings. Under Section 69, 3, an unregistered firm cannot claim a set-off or initiate other proceedings to enforce contractual rights. However, there are important exceptions. Even if the firm is unregistered, partners can file suits for dissolution of the firm, for account of a dissolved firm, or for realization of the property of a dissolved firm. Thus, while registration is optional, the severe legal consequences of non-registration make it practically essential for every partnership firm. This provision promotes transparency and allows any interested person to verify the details of registered firms and their official records. Section 70. Penalty for furnishing false particulars. Section 70 of the Indian Partnership Act, 1932 deals with penalties for furnishing false information. If any person signs a statement, amended statement, notice, or intimation under this chapter and knowingly provides false particulars, or includes information which he does not believe to be true, he can be held liable. Similarly, if the information provided is incomplete, and the person knows or believes it to be incomplete, liability also arises. In such cases, the person may be punished with imprisonment for a term which may extend up to 3 months, or with a fine, or with both. This provision ensures honesty and accuracy in the information submitted to the registrar, thereby maintaining the integrity of official records. Section 71. Power to make rules. Section 71 of the Indian Partnership Act, 1932 empowers the state government to make rules for carrying out the provisions of this chapter. Under subsection 1, the state government may prescribe the fees payable for documents submitted to the Registrar of Firms, for inspection of records, and for obtaining copies. However, such fees must not exceed the maximum limits specified in Schedule I of the Act. Further, under subsection 2, the state government is authorized to make rules on various procedural aspects. These include prescribing forms of statements and their verification, fixing formats for notices and intimations, determining the form and maintenance of the Register of Firms, regulating the procedure in case of disputes, managing filing of documents, setting conditions for inspection, regulating grant of copies, and even providing for maintenance of indexes and elimination of records. In general, the state government can frame rules to effectively implement the provisions of this chapter. Subsection 3 provides that all such rules must be made after prior publication, ensuring transparency and public participation. Thus, this section gives administrative flexibility to ensure smooth functioning of the registration system.